Good afternoon and welcome to our today's program on Know Your Rights, addressing the mental health discrimination in the workplace and home. I'm Eric Scharf. I serve as the Federal Advocacy Advisor for DBSA, where I track and advocate for public policy affecting people who live with mood disorders. As a person who lives with a major depression, I can share firsthand how many of the topics we address today directly impact on those with a range of mental health issues. Joining me today is Abram Hyatt, who has been a staff attorney at Disability Rights DC since early 2019. He is primarily responsible for helping individuals with disabilities secure adequate vocational rehabilitation services from the District of Columbia. Additionally, he advocates for beneficiaries of the Social Security, disability insurance, and the supplemental security and income programs, and works to ensure that individuals with disabilities are afforded their rights secured by the Help America Vote Act. Before joining Disability Rights DC, he was a graduate of the University of Michigan Law School. While in law school, he completed internships at the Disability Rights section within the U.S. Department of Justice's Civil Rights Division and the Minnesota Disability Law Center. Welcome. Hey, we're very glad to be with us here today. First, just a disclaimer we need to offer. We're going to be, the information we are offering today is not personal individual legal advice. We're not able to address any question with regard to a personal situation. We suggest that you contact an attorney in your community if you have specific concerns. Our agenda today is simple. We're going to review a number of learning goals. We're going to identify what your rights are under the legislation for workplace, for housing, health insurance, to help you learn what strategies you can address these issues with, and review what community resources out there exist to help with that. Before we get started, though, invite you to use our Slido feature, which is going to help us answer some questions from the audience. You can either use this QR code on the screen with your phone to bring it up on your phone. Give you a moment here to do that. Or you can go to slido.com on your computer and enter the code advocacy track, all one word, in that blue box at the top. When you've done that, in the slido.com presentation, look for in the drop-down Friday, 1:00 p.m. And the name Eric. That's the program we're in today. Hope that most of you can do that and join us, because we've got some fun, interesting questions to ask as we go along here. Now I'm going to turn it over to Abe, and he's going to do our first section. Thank you.
Thank you so much, Eric. Yes, as Eric said, my name is Abe Hyde. Happy to meet all of you and do this little presentation on disability rights. So just to sort of give a very broad view right now, what we're going to be talking about, both Eric and I, are basically three specific areas of disability law that might be applicable to the work that you all do. In this instance, it's employment and services, access to employment and services, it's access to housing, and access to health insurance. I'll be talking about those first two sections, employment, service, and housing. There are specific laws that govern all of that stuff on there. You can see we've listed them there. Those are the most relevant ones. Of course, there are many, many, many more laws that govern interactions in these areas. Housing and employment services might be state laws, other federal laws that govern specific situations. So it's just very important as a lawyer that I tell you that you should be aware that what the information I give you is not going to be expansive. It's not going to cover certainly not every situation you run into, and certainly not all the rights you might have. So you can go to the next slide here. But what I am going to cover is the Americans with Disabilities Act, which I'm sure that many of you have heard of, maybe all of you. It was signed into law in 1990, pretty recent. It built on some older disability laws, and generally in doing so allows people with disabilities, it gives them a mechanism to assert their rights as individuals with disabilities, to access certainly equal rights in the workplace, ideally, and also government private services. You can see we've got the 5 titles here. The last 2 aren't going to be very relevant for what we're doing right now. It's the first 3 that we're going to focus on: equal employment, discrimination in state and local government services, and discrimination in public accommodations and services operated by private entities. The next slide here. So a very important thing with all of this is that individuals can't get the protection of the ADA or other disability laws unless they qualify for protection under those laws. The way that this is done is basically there's a standard that's set out that determines when someone is an individual with disabilities. In the case of the ADA and other laws, it's that the individual must have physical impairment, a physical or mental impairment, I should say, that substantially limits a major life activity. And in the case of workplace discrimination, you also have to have the ability to do the job with or without a reasonable accommodation. There are other things I'll talk about a little bit more, but those are sort of the big general ones. So we can go to the next slide. So the big major thing to focus on is, of course, those first two prongs, really, the physical or mental impairment that substantially impacts a major life activity. So there's a specific list of major life activities. You can see that we've got it there. Those are specifically dictated by the law itself. So basically, the idea here is that if you're able to show that you have, some impairment that results in limitations to your major life activities, substantial impacts, I guess I should say, then you can qualify for protection under the ADA. Just without going into a lot of the history, this used to be a lot more fraught than it is now. In 2008, the law was amended to essentially broaden the definition of disability because a whole bunch of courts were doing pretty ridiculous things. There was one case that pops to mind where an individual was a truck driver with monocular vision, so he could only see out of one eye. He'd been doing it for like decades, but when his employer found out, his employer fired him. And then he came in to court arguing that he had been discriminated against on the basis of his disability. And the court determined that he wasn't disabled because he was capable of working. So there's like blatant disability discrimination. I mean, there's nothing clearer than discriminating against someone for being, blind in one eye. And yet there we were. So they changed the law to encapsulate basically a new medicalized definition of disability, including major bodily functions, which you can see there on the right of your screen. So if you have essentially a medical issue that affects one of those areas, which is not an exhaustive list, I should add, then you can also qualify for protection. So this also used to be like less important. The other thing to keep in mind is that the impairment must be substantial. So you can't just, come in and say your life isn't really impacted in any way. So we can go to the next slide. Eric, can you go to the next slide?
There we go.
That's right. There are two other ways to qualify that sort of get us around even the substantial requirement. I'll just touch on them very briefly. The person can also just have a record of an impairment. That means that if in the past you were doing, struggling or something with an impairment and you no longer are, it sort of prevents an employer from arguing, or employer or anyone from arguing that you don't get protection on the basis of yourself doing well at this point. So a classic example is person in remission for cancer. Can't be discriminated against just because they're now doing better. If the employer says, I don't want people with cancer working here. The other thing is this other very strange one, which is that if you're regarded as having a disability by your employer, you can get protection. So uniquely, that means that you can get protection even if you're not a person with disabilities. This is really meant to protect people from if they can't qualify, if there's some impairment they have that's doesn't rise to the level. For instance, regular pregnancy is not considered a disability under the ADA. If your employer says, I'm firing you because you're pregnant, granted, you also have other rights under other laws, but you could also theoretically argue that, they regard you as being a person with disabilities, even though it's not a disability because your employer thought it was disability. The one catch here is that uniquely, this provision doesn't apply to temporary or minor injuries. So next slide. Okay, so now we finally we're done with qualifications, so we can talk about the actual rights that you have. I split this into two little areas. You have some rights at the stage where you're applying for a job, and you also have some rights, obviously, once you get the job. In terms of applying to jobs, the interactions you can have with an employer concerning disability issues is really tightly regulated. Employers really can't ask any questions that are not only going to reveal disability information, but even might reveal disability information. So if your employer says to you, were you ever hospitalized in the past? No, not at the interview stage. So it basically prevents all types of questions like that. They can require a physical after they've already offered you a job. And if that physical then reveals that you genuinely cannot do the job with a reasonable accommodation, or reveals that there's some danger to you working there, then they can rescind the offer, but that's obviously rare. The other thing that happens is after you're employed, once you've gotten the job, this is much more important, you see this all the time, you're entitled to reasonable accommodations. I should also add, you are entitled to reasonable accommodations in the interview process. And the sort of way that you can request and get those accommodations is similar in both the interview time and the workplace time. And this is sort of where I'm going to focus on a little bit more. So once you get a job, as I said, you can get reasonable accommodations. Also, you can't be discriminated against on the basis of disability. So your employer can't just fire you because you're a person with disabilities. And also your employer can't generally require you to disclose certain disability information. Certain things are reasonable and reasonable. We'll get to that in a little bit. One thing that is not covered is you don't have any protection for illegal drug use. And it's something I'll always add in here is the use of marijuana is still illegal federally. So keep that in mind. Obviously, states have legalized it, but they don't really have the power to do that because the federal government says, no, no, no. So we can go to the next slide. So this is sort of the mechanics. We'll talk about the mechanics of accommodations. It's just a general slide we got up here. I'll say that, generally what should happen is you should document your request. That means collecting reasonable documentation about the impairment and its effects and your need for accommodations. Then you actually have to make the request. You have to tell your employer, hey, I need accommodations. This is why. And then finally, it can resolve with the engagement in the interactive process. Now, notice I put two little arrows up there. This is because I just really wanted to highlight that you should never let the lack of documentation at any given point prevent you from making the request, because until your employer is on notice, until they know or should know that you're a person with disabilities who needs accommodation, they have no responsibility to do anything. So if someone's been putting off a diagnosis, putting off going to a doctor to get something formally in writing or something like that, they shouldn't let that stop them from making a request. The worst that happens is their employer says, give me the documentation. And even then you bought time. I mean, you get time to obtain, it can even be reasonable to say, I need time to get those documents. So the most important thing here to note is that you just shouldn't first of all make a request merely because you don't have documents. You should make the request. You can go to the next one. So this slide is about those documents that might be required. So employers are not necessarily required to act when the need is not obvious, as I just said a moment ago. In many cases, we can imagine there are situations where the need is obvious. If someone shows up to work in a wheelchair and they don't have use of their legs and the bathrooms are all, I don't know, somehow inaccessible. Yeah, that would be a scenario where probably someone would not have to make a specific request to make their employer aware that they need some kind of assistance. However, many of the conditions, of course, people that you're working with are going to have are not going to be readily visible, I should say, on their faces. So that can require notice to an employer. Obviously, you can construct situations where it would become, evident someone has a panic attack during work and yells about having terrible anxiety. Yeah, the employer probably knows about it in that case. But, generally, I caution that when the need is not obvious, you need to provide some kind of notice here. So expanding on that, there's a question of what kinds of documents are required. So your employer can make unreasonable requests for documentation. And this is an area that's heavily regulated in other parts of the ADA when it comes to telling us, what's going on. But in this case, you really do want to focus in on sort of the nature of the disability, the need for accommodation, how the accommodations will help you get the job. The employer can't really ask for more than that. They can't demand a whole bunch of medical records or anything like that. It's really only about, your request and sufficient to show your employer that, yes, you need this. And they're not really entitled to make demands about the type of professional or anything like that who's writing you the note. Obviously, doctor is probably one of the things that would be reasonable. If your mother or something writes a note, and that not be sufficient. But the employers are somewhat constrained here. So we can go to the next slide. And then this is about making the request. Any communication, as I sort of implied with the I have anxiety exclamation, can be enough to sort of trigger the employer's notice. No magic words are required. No specific forms can be required, although employers may, in the context of sharpening the request, ask that you fill out information about it, which is okay generally. But you should really try and make the request clear. I mean, you do not want to get into a fight after you've been fired over whether or not your employer really knew that you were a person with disabilities who needed accommodation. That's just something you want to avoid. So it's important to be mindful of that. It just is in every situation better to be like, hey, I mean, even just say the words accommodation, I need an accommodation. That's it. And then in terms of the nature of the requested accommodation, you will know that from what I just said before, you can make a specific request and say, this is what I need. But you don't have to. It's sort of incumbent upon your employer and you working together to figure out what is feasible, what is available, and make that determination from there. It's also, just as a lawyer, I'll tell you, a good idea to make that request because it sort of sets just a negotiational baseline. The worst that happens if you've asked something your employer is going to say no to, and that is a thing they can try and do, but it's better than starting from zero. And also, employers generally don't know what types of things to do and might have ideas that aren't as expansive as might address your needs. So the one other caution I will add is that you should be careful about how you explain what the need for accommodation is. If you shoot for the absolute moon, it might imply to your employer that you can't actually work there and give them justification to refuse the accommodation. That's sort of rare. You can see courts ordering employers to do pretty incredible things. One case comes to mind. There was a legal aid attorney in New York City whose employer offered train subsidies for employees to get into Midtown Manhattan. The employee had a disability that prevented her from riding a train without extreme discomfort, and she asked that her employer pay for her to get a parking space in Midtown Manhattan, which essentially doubled her salary. She was getting paid like $45,000. That's how much it costs to get a parking space too. And the court ordered that the employer do it. So, it can be expensive, and I'll talk a little bit more about that later maybe. So the next slide is about the interactive process. This is important because it's a requirement on both the employer and the employee. It requires you work together with your employer to try and figure things out. Rarely will you succeed on saying your employer didn't do a good enough job here. Counterpoint, rarely they will succeed on saying you didn't do a good enough job here. But it just this is a process that exists to help you see if you can come to an amenable solution so you don't have to involve people like me. As you can see here on the left, the employer in the interactive process can, of course, grant, obviously, the request or suggest alternatives. That's fine too. They can also deny on the basis of undue hardship or direct threat. Sort of hinted a little bit about that before. Undue hardship basically means it would be too expensive or impractical for us to do this. Direct threat is it would be your mere presence here causes a danger to either yourself or others. Very rare for direct threat. I don't even want to speculate about the types of cases where that appears. And then the requester, the person requesting accommodations, they have to work with the employer, even if they think the employer is being pretty unreasonable. Still got to work with them. Because again, the worst case scenario is the employer can say, well, they didn't even try. And then you're just stuck in this sort of cycle. So even if you feel your employer is being unfair, important to work with them, important to try. And that sort of covers the reasonable accommodation. Now, there are, of course, many accommodations that are going to be acceptable and unacceptable. I mean, I've talked about a few of them. I guess I'll say a little bit more about undue hardship. That prong concerns mostly cost. Also, staffing can be an issue if you request something that's essentially impossible for the employer to do because they have too little staffing. That's another thing that would not have to be done. But you can, again, see sort of incredible things getting approved in these areas, not just monetarily, but just minor rules, and by rules, I should be very clear. I don't mean like your employer has a handbook that says this thing. It's just basically any determination that your employer is doing. If he's saying that you have to show up at 9 o'clock, and if you're ever a second late, you're in trouble, you can probably get them to modify that a little bit. There are scenarios where it would be unreasonable, but for the most part, the ADA requires some flexibility on the part of employers. Employers generally understand that. Doesn't mean they won't fight it, but they generally understand it. So now we can go to the next thing. We're going to be talking a little bit about Title II and Title III very briefly. These are the provisions of the law that govern your ability to get accommodations in state and local government services, and also private services. For state and local government, there is another law that governs federal government services. It's called Section 504 of the Rehabilitation Act. It works similarly. In fact, something I'll say is basically all of the laws in this area specifically cite to each other. It's a whole pretzel of a whole bunch of laws saying this thing works just like this thing. So here, that brings us to our first part on Title I and Title II, actually, is you qualify for protection the same ways you do under Title I. Sorry, I said Title I the first time. Title II and Title III qualify same way as in Title I. For Title II, it applies to state and local government and also like their instrumentalities, so public transportation, stuff like that. Like Title I, they can't exclude persons because of disability. Like Title I, it also requires some changes to their practices. Reasonable modifications is the term we use here. It requires that they change rules, practices, physical barriers in this case, and communication methods so they can work with people with disabilities. So, for instance, deaf people are entitled to interpreters so they can interact with government services. Physical changes can be required to buildings. New construction obviously have to include them, and elsewhere there's sort of a test about whether or not it's reasonable, feasible to put in changes like a ramp or something like that. Less relevant to what you are all doing, but basically this is all to highlight that local governments obviously can't discriminate against you, but discrimination includes failure to make reasonable modifications to policies, practices, rules. It works similarly in Title III, basically exactly the same with a couple details. The first is just to be super clear, Title III entities are basically any private entity that engages in like commercial activities. So don't think that this is just like, I don't know, stadiums and stuff. It's any business. That's who's covered by Title III. Really, the only private entities that aren't covered by this are ones that are specifically exempted, like the airlines for some reason, or private clubs, truly private clubs, like not golf clubs. I'm talking about like private clubs whose membership is not, permitted to outside as fraternities, things like that. So it's basically any business. The one thing here is that they have to make reasonable modifications, just like Title II entities. The one, sort of thing to keep in mind though, is that there is a cost benefit thing here for them. And I shouldn't say cost benefit. There's a cost thing, an undue burden type thing that prevents them from having to do things that are unreasonable. And also fundamental altercations. That's a big thing. If it would truly change the nature of the service, like if you're demanding that a company make an accessible car, Ford Motor make like a car that I can use, no. You can't force them to make new cars because that fundamentally alters the service. So we can go to the next slide, which I think is a quiz under Slido. Go through it real quick. Obviously, you can read it here. But if you pull it up, the questions are under the ADA, and individuals experience discrimination in following situations: termination of employment because of past hospitalization, mental health condition, failure to provide reasonable accommodations to apply for a job, or inadequate access to a public building. I don't know. What do you think? So you can enter the answers into Slido. I guess we can wait for that to happen.
We will slow those down, see what people think. Well,
oh, skipped it.
There we go. Yep.
Great. Good answer on the first one. I'm going to assume the other people. Oh, of the presume. There we go. They're coming in. So I'll just cut this short because I know that we got running low on time here. Yeah, all of them are actually generally going to be discriminatory things. Obviously there's, with everything, everybody hates lawyers because you say, so they're devils in the details, and it depends on where you are. This is all true here. Failure to provide reasonable accommodation to apply for a job is, of course, one of the things that we talked about. Inadequate access to public building. Yeah, sure. It depends on the building, truthfully, but generally, yeah. So now we can go to the next thing, which is going to be Fair Housing Act stuff. Fair Housing Act, again, works similarly to the ADA, except it's much more expansive and doesn't just apply to people with disabilities. It applies to basically like everything in housing. So it's a pretty expansive law. I'm going to speed through it. Prohibits housing discrimination by landlords, municipalities, banks, things like that. This is obviously a big problem in racial discrimination for a long time, so that's why the law exists. And it covers, as you can see, the categories there. Next slide. Disability is defined just like it is in the ADA. In fact, it incorporates the same definition, so we can just go right ahead. The Fair Housing Act generally protects people when they apply for housing. It's in renting or buying or selling. It also prevents discrimination, so any forms of like discouraging access or limiting access to people with disabilities. It can require modifications to buildings depending on the entity that it is, and it certainly does require allowing modifications. And then finally, it does, just like those Title II and Title III rules, require alterations to rules and policies. So you have to make accommodations there. So yeah, the protections provided, as I said, are in sort of, renting, basically any form of housing getting. So again, this was more relevant elsewhere, all of racial covenants, things like that. There used to be an apparatus to discriminate against people on the basis of race in terms of housing. It less so exists. People with disabilities, more it's sort of, discrimination by people who just simply don't want to deal with the hassle of someone with disabilities. We do see that all the time. It doesn't tend to be as institutional. It does tend to be individualized, though. I mean, it's all over the place. So something to keep in mind. In terms of what rights you're provided, modifications to spaces. This is not very expansive, unfortunately. Like your landlord doesn't necessarily have to allow a change, or sorry, doesn't have to pay for a change. They do have to allow a change. If you say I want to install a call box so I don't have to go to my door or something, they have to allow you to do that without charging you anything. There can be situations in which a housing provider has to make some modification. New buildings, if something hasn't been done in the way that is outlined in the exhaustive requirements of the accessibility standards for the ADA, all of the laws, really the FHA accessibility standards in this case, your housing provider can be required to make a change like that. Again, new construction only. And then there are other things, like if they're receiving federal aid, which is true of public housing generally, they may have to make some certain changes, certainly in terms of cost. Things like installing ramps really comes to mind in this case. And again, we do also have those restrictions: undue burden, fundamental alteration. So undue burden would be cost. Fundamental alteration would be if a landlord doesn't provide some service, they can't be required to do it. If there's no, I should say, if there's no like similar service they're providing for people without disabilities. So the next slide, we can see reasonable accommodations, which are actually universally required. This is not like the modification thing. Just like in Title II, Title III, it's rule changes. That's what we're talking about. Housing providers have to change the way they do things. This can be pretty expansive. Again, you know, landlord says we take rent at the end of the month, and then someone says, or sorry, that's a bad example. Landlord says we take rent all the time on the 28th of the month, and someone says, hey, I'd like to live here, but I only receive my SSDI, my disability payments, on the 30th or the 31st, last day of the month. Can you please wait until then? They say no, that might not be allowed. They might have to accommodate that kind of request. So you'll see a lot of times, we've all seen it, even if you're not dealing with disability discrimination, landlords are notoriously sticklers for their contractual arrangements. These laws don't allow them to contract around these things. They can't just point to this document and say, you signed, buddy, you can't waive these rights. So it's always worth asking if you want to get some change. Again, there are those reasonability restrictions: undue burden, fundamental alteration. Can't make your landlord start a recycling program if everybody else has to go to the dump to do their recycling, if you have mobility disability or something like that. But they do have to change like even neutral laws, waiving lease fees and things like that. I'll say it very briefly. Sorry, lease change fees is what I meant. So I want to move to a room that's more accessible. Landlord comes and says, well, you got to pay $300. Everybody does when they want to change their room. You can say, no, it's for disability. So I will say briefly, I think there was another presentation about this, so I'll only touch on it briefly, but this is obviously a hot issue, emotional support animals. ESAs, emotional support animals, are covered by the FHA. They are not covered by the ADA. ADA only applies to service animals, which have much more exacting requirements on them, although more rights than ESAs do. ESAs can be any animal. Ostriches, I've heard of someone with one. Peacock, it can be anything. Your landlord can place reasonable size requirements. Elephants probably not going to be allowed, and that would probably be pretty reasonable. The ESA must be permitted. It's not a pet, so pet fees and things like that don't apply to it. Of course, if the ESA does damage or is seriously upsetting the ability of other people to enjoy their quiet enjoyment of the residence, the landlord can say you can't have that ESA here anymore. And I sort of hinted to this, if your animal damages something, you can also have to pay for it at the end. But again, no fee on the front end. And the sort of requirements for documentation is similar to what can be required in the context of a workplace with those accommodations. Different here, I'll just highlight to say service animals, generally lower requirements, and landlords, stuff like that, can really only ask, what does it do? What does the animal do? And that needs to be sufficient. You don't have to provide basically any documentation. So now we got my final quiz. Next one. Okay, so under the Fair Housing Act, an individual has experienced discrimination in the following situations: making housing unavailable or lying about the availability of housing, refusing to make a loan or setting different loan terms, being discouraged to select a specific option. So those are the questions. Let's see what you say. Nope.
We got the answers here.
I know.
Huh. There we go.
There we go. Oh no, we actually ended up a different question. Last,
Well.
but it's okay. They were all discriminatory, so hopefully you all got that. And I thank you all. Now we're going to switch over to Eric to talk about more about health insurance. I hope you enjoyed my quick run through. There's obviously, as I said, a lot more about all of this, but hope you enjoyed it. Thank you.
Okay, thank you, folks, and thank you, Abe. I'm going to now take over and talk about how you obtain health insurance, how we ensure that it provides for you with mental health issues. As you may be aware, there are a variety of different options to accessing health insurance. You might be a part of a group health insurance program that's sponsored by your employer. Rules tend to vary in terms of the size of the plan. You might be in what's known as the healthcare marketplace or exchange. If you're a single individual or family that's not in a with an employer that provides insurance, you can go to one of these, again, state or federally run, depending on your state, marketplaces and buy insurance there. Or you might be in one of the government programs, for instance, the Medicaid or the CHIP program for children, Medicare, Federal Employees Health Benefit Program, one of those. You may be aware that the federal government is trying to expand insurance opportunities for folks, something we've been working on very closely. Here's another survey. This one has to do with insurance, what you understand about insurance. Click on which ones you think are true. I'm going to give you a moment to do that, and hopefully it'll work this time. Let's see. Okay. There we go. I think now we should be able to see the answers. There we go. Okay. Well, the answer is, I see, is all of them are true, actually. A deductible is, as it says, is the amount you pay before your insurance company will start paying that claim. For a lot of people, it's like $500 or $1,000. In-network providers are those that the insurance plan has designated and gives a better preferred rate to, and lower for you if you're not using the in-network providers. Co-insurance is that percentage that you pay for a claim, and the copay is a fixed amount that you pay for a claim. So what is mental health parity? This is a law that was passed in 2008 that mandated the basic concept that mental health benefits needed to be equal to physical and surgical needs. It was enhanced in 2014 with the the Affordable Care Act, and then later on various Medicaid regulations came that extended it to managed care organizations. So it's a law that's been incrementally developed over time. It's probably important to note that really the major gap in federal parity law is that for Medicare. So that Medicare, while it provides mental health benefits, do not necessarily provide them equally to the medical and surgical benefits. The categories that are included in the parity law include outpatient care, inpatient, prescriptions, and emergency services. So it's the breadth of healthcare services that it addresses. So parity, it means equal to. So for instance, if you see a cardiologist and you're eligible to see it for 12 times a year, you need to have the ability to see your psychiatrist 12 times a year. If your out-of-pocket expense to go see that cardiologist is $50, then when you have your psychiatrist appointment, it can only be $50. Same with the deductibles. It gets, there's some additional things in terms of what's known as non-qualitative limitations. Not going to get too much in the weeds on that, but there are some different ways that they look at that. So how does parity increase your access to care? A variety of different ways. By this comparable coverage plan is an important piece of it, but also because it provides rules around what's known as medical necessity and getting prior approval. And again, those types of access need to be comparable to your physical and surgical benefits. And then finally, the various mandates about making information available to the consumer, to the subscriber. So for instance, you've probably heard of a drug formulary, a list of drugs that they will pay. Again, there has to be a similar type of drugs and similar quality of drugs. So they can't, you may be aware in some drug plans, they have what's known as preferred drugs and non-preferred drugs. That's the difference between newer drugs and generics. They have to be sure that they're not putting all of the new all the mental health medications into the top tier, and the most unavailable ones, while they have lots of generic drugs available for your other physical type of claims and whatnot. Again, the rules on all this kind of vary depending on the types of insurance companies and the types of plans, but the basic premise is still there. And as I mentioned, the concept of NQTLs, non-quantitative treatment limitations, these rules are talk about what must be comparable and applied no more stringently to get into doing comparative analysis. Again, a little bit complicated at times, but important to be aware of. So comparable coverage. This means that a plan can't have limits, but it doesn't mean that the plan can't have limits, but they can. But those limits have to be comparable. So for instance, Brooks, who you see here, lives with a pulmonary disorder. He went to the doctor, was diagnosed with pneumonia. Because of his medical history, his doctor believes he should be hospitalized so that Brooks can have the best chance of obtaining wellness. This should also mean that if Brooks experiences a bipolar episode, that he is not responding too well in his current treatment protocol, and his doctor recommends hospitalization, he also gets to have those benefits of hospitalization. However, the plan requires a pre-authorization, and that care can be delivered using in-network benefits and facilities. This would mean the plan can set limits on his medical benefits, whether that is for the medical, surgical, or the mental health. The point is that the mental health restrictions cannot be anything more restrictive than the medical surgical benefits. It's important we know that as well as our physical health benefits, as well as our mental health benefits, as what's provided. Let's talk a little bit about this concept of medical necessity. Medical necessity are the set of rules that insurance plans use to decide if they're going to cover a treatment or service. Think of medical necessity as a set of rules that govern all the different types of treatments you can get. Each plan can have its own set of rules, but they must consider these kinds of things. Is it reasonable? Is it necessary and or appropriate? Is it based on evidence-based clinical practice or standards of care? Those are the basic principles of what medical necessity is about. Unfortunately, we see instances where they use medical necessity as a barrier and a blockage, and we're going to come to talking about that in terms of how you advocate for yourself. These transparency requirements. In the past, insurance plans were the ones who knew what the rules were, and they just didn't let you know what they were. They could deny treatment by saying it doesn't meet those criteria. Now they have to tell you what that criteria is upon request. They have to give you the reasons for those denials in writing. Those documents related to that plan compliance with Parity Act have to be made available for appeals. Carrier cannot withhold the documents based on proprietary information. They have to provide those reasons for you, and there's a variety of other disclosures now that are made public to you. So who regulates Parity? This is complicated because while it's a federal law, they have delegated to the state insurance companies much of the sort of compliance aspects. But it also depends on whether it's a employer group plan, which the Department of Labor primarily regulates, or a governmental plan, maybe a state and local plan, or some other types of plans are regulated by the Department of Health and Human Services. But the best entry point is through your state insurance department. We are working with Congress to tighten up the enforcement and compliance rules to give the Department of Labor increased authority and enforcement powers in terms of making fines against insurance providers and those kinds of things. We're also working on legislation to provide states with funding so that they can enhance their enforcement provisions. We're excited about that. So what are the steps to appealing a coverage denial? So say, there was just an example I was reading in the New York Times this week about a family where their child was getting treatment for bipolar in Chicago, and after 30 days, the insurance company said, well, we're not going to pay for that anymore. They sent the child to another place and got a few days of coverage there. But again, they said, we're not going to pay for it. The three major steps for addressing that. One is collect all the relevant information. Your plan name and the numbers, your member IDs, your dates of denials. What were the explanations for those denials? Request that from the plan, as I said, what were those non-quantitative treatment limitations? What was the criteria they used for determining the medical necessity? Why did they deny it? Any other evidence? All of that material is available to you free of charge. They cannot charge you for those documents. They can't charge you copying fees, all that kind of stuff. They have to provide that to you. More and more, much of that they're doing online now, which is helpful. We are seeing insurance companies being better about this, but there are still issues out there. So the second thing is take action. Ask the provider to act on your behalf. your doctor or the treatment plan place you went to, ask them if they can help you. The various organizations out there are out, like people like the organization ABE works for, do a lot of this kind of work. You can file an internal appeal at the insurance company, either verbally explain the issue, write a letter to the appeal department at the insurance carrier, and see if they can resolve the issue. Sometimes, quite frankly, it's within a large insurance company. It's just sometimes an issue of one department not being on top of what the current rules are. Number three, though, if that doesn't seem to work, don't give up. File an appeal with your state insurance commission. They will help you figure out whether you need to go to the state attorney general, whether you need to go, if it's an ERISA claim, go to the federal government. Again, potentially seek legal representation if it's sufficient, and go in that direction. There are people out there that are here to help you with this sort of thing. So what resources are out there? Lots of them. The Kennedy Forum has an excellent guide on parity resources. The federal government website for SAMHSA, for the Department of Labor, both have excellent websites on how to ensure your parity obligations. DBSA can help point you in those directions. So feel free to go after and seek resources in those areas. Okay, we've got a quiz here for you. And by the way, if you have any questions, put those into the chat box. We're going to be ready to take questions here in a moment. So for each of these questions, which do you think are true or not? I'll give you a moment. Okay, let's see if we can get the questions to come up. Let's see, there we go. Okay. So the first is false. The government is not responsible for enforcing the rules. They, at this point, they are really responsible for ensuring compliance by the various insurance plans. Second one, the ACA, the mental health parity rules do not limit the amount the insurance plans can set for co-pays when it comes to medications. They just have to be equal. Also, an insurance company is allowed to have separate deductibles for mental health. No, the plans do, the rules do require that there are no separate deductibles. They can't have one for medical and one for mental health. It'll be the same deductibles. First step here is filing an appeal, filing the appeal is to collect the relevant information and to follow those steps on how to use that fact sheet. I think we put up in the handouts on the conference website here a handout we have on how to do the appeal process and the resources. So with that, here's contact information for myself or Abe, and we welcome your questions at this point. So let me stop share on here, and Andrew or Meg, do we have any questions to from the audience?
Yeah, we have one question. Do these laws provide privacy protections? Say your boss can't tell coworkers who don't need to know about your accommodations, or like the landlord can't tell other tenants specifics about your condition.
Sure. So there are a whole bunch of laws that do things like that. HIPAA is one of them, although it doesn't imply in the context of like, your employer is not governed by. I'm not an expert on HIPAA, but I do not think that your employer is just like bound by HIPAA. There's GINA, which prevents the disclosure of genetic information, which your employer is probably not what you're talking here. And this is an obvious stall for time on my part. The long answer, the better answer is probably that I'm not 100% certain. The ADA certainly doesn't have any specific provisions in it that require employers to keep this information secret. However, it would behoove an employer not to release any information like that, because it would sort of open up the box of allowing people to think that they've been discriminated against. So of course, if your employer is doing things like that, they could get in trouble. It is possible, actually, now that I think about it, they might be a HIPAA covered entity once you give them medical information for purposes of accommodation. So I would look into that more. It doesn't come up much. But yeah, generally you are entitled to some form of privacy, but other than HIPAA, there's nothing that really pops to mind.
And I apologize, I got a message from our Zoom jockey earlier, but I missed it, saying we had a visually impaired participant today asked for an accommodation for more time, and we missed that. So I apologize to that participant that we did not do that, but that is something we need to be better about. Someone also asked about getting a copy of the slides. We are going to put those into the handout section on the leadership forum after this event. But in the meantime, you have my email address on that final slide. I can put it in the chat box, and happy to also send them to you directly. So any other questions? We got a couple more minutes, I think. Yes, okay.
Do you have any advice for group members who have been denied disability insurance for bipolar-based disability?
So if you're talking about something like SSI or SSDI, it's really hard. So first of all, what I'll say is that I can't actually legally give advice on that issue because of specifically my organization does do work in that area, and we're prohibited by law from giving advice about how to qualify for disability. What I can say is there are plenty of organizations that do allow it, and what you should do is you should look up basically whatever state you're in. You should look up my organization, so the Protection Advocacy Organization, and then they can send you to an entity that they'll probably have a list of lawyers, private or public lawyers who do this type of work, who can send you to resources for that kind of thing. But what I can say is that I do sympathize. Obviously, it's difficult. Sort of the whole thing is in some ways set up not to accommodate the needs of people with certain types of disabilities. And obviously, it can feel harder if you're dealing with simply mental health rather than, something missing a leg or something like that. So my advice would be generally, everybody's turned down the first time, but I can't say that with 100% certainty. And then beyond that, I can't really give any advice. Sorry.
And Meg, was that because I think I heard the question also had to do with disability insurance. Was that people who want like short-term disability insurance, or?
Do you mind if I unmute you so you can clarify your question, Stephen?
Yeah, I guess I meant SSI, I think is what I.
Oh, was SSI? Okay,
yeah.
fine. Yeah. The reason the question has come up in the past about people who have long-term disability insurance plans and whether they can discrimination in those issues, and that we found is a tough nut to crack. There's been some issues around there, so I want to make sure I would.
Thank you both. Appreciate it.
Yeah. Okay, well, we have one more minute here before Andrew cracks the whip on us to get ready for the next program. But any other questions?
No more questions in the chat, so.
Okay. Well, we want to thank you all for attending today, and I want to thank Abe for helping us out with this on behalf of DVSA. Great program, great presentation, and we look forward to continuing this conversation. Andrew, do you have any comments you want to make before we start the next session?